Day at Trust Class, Days 4 and 5. Author, Bard Justis. Chapter 28. Footnote by Footnote, a closer look. The classroom was abuzz with excitement. After days of exploring express trusts, the students were eager to dig into the specific footnotes from WEISS'S Concise Trustee Handbook. They wanted to uncover the meanings behind each reference line by line in the opening section. Miss Hamilton smiled at her students' enthusiasm. Today we'll go through the footnotes in the first section of WEISS'S Concise Trustee Handbook. She began. We're going to decode these references so you understand the deeper context of express trusts. Let's start with the first footnote. Footnote 1. The General Law Merchant. Miss Hamilton read aloud. The general law merchant is embraced under general common law, that is, the original and unique system of commercial law in the American states, in which there is no commerce regulation of express trusts, except in connection with income derived from corporate stock and physical franchises under Art. I. Section 8, CL 1 and 3 of the Constitution. See William A. Fletcher, The General Common Law, and Section 34 of the Judiciary Act of 1789, the example of Marine Insurance 97 Harv. L. Reverend 1513, 1514, 1984. She explained, this footnote refers to the general law merchant, a body of commercial law that predates U.S. statutory law. This law operates under common law principles governing how property and business transactions take place without heavy regulation. Essentially, express trusts can function independently in commerce without interference, except when they involve certain kinds of income like that from corporate stock. Jamie raised her hand. So, does this mean express trusts can operate like businesses? Almost, Miss Hamilton replies. Express trusts operate privately, similar to businesses, but with fewer requirements for disclosure or regulation. The key here is that they're governed by general common law principles, giving them flexibility and protection within commerce. Footnote 2. The belief of Chief Justice Warren E. Burger. Miss Hamilton continued to the next footnote, reading, it was the strongly held belief of U.S. Supreme Court Chief Justice Warren E. Burger that 75 to 90% of all trial lawyers are either incompetent, dishonest, or both. See 102 Reports of the American Bar Association, 205, 206, 1978. She explained, this quote reflects Chief Justice Burger's skepticism about the legal system's handling of trust law. He believed that many lawyers misunderstood or mishandled complex trust structures, particularly express trusts. Weiss includes this footnote to emphasize that express trusts are often safer in the hands of those who understand common law principles, rather than traditional trial lawyers who may not fully grasp the nuances. Tom raised his hand. Does that mean people could set up express trusts without lawyers? Potentially, yes, Miss Hamilton replied. With proper understanding and guidance, individuals who follow common law principles might feel empowered to create express trusts independently. Weiss is suggesting that expertise in common law might actually be more beneficial for managing an express trust. Footnote 3. Learned in the law. Black's Law Dictionary. Miss Hamilton moved to the next footnote. Black's Law Dictionary, p. 695, 1st ed. 1891. This footnote, she explained, refers to the term learned in the law, which historically described lawyers as individuals who deeply understood legal principles. By citing Black's Law Dictionary, Weiss is emphasizing that the concept of being learned in law goes beyond technical knowledge and instead suggests a foundational grasp of principles, particularly those rooted in common law. Rachel raised her hand. So express trusts are really tied to old legal traditions? Exactly, Rachel. Miss Hamilton confirmed. Express trusts rely heavily on common law, which is grounded in these historical legal understandings, allowing them to operate outside typical statutory frameworks. Footnote 4. The basic definition of a trust. Miss Hamilton read aloud. Black's Law Dictionary, p. 1513, 7th edar, 1999. An even more basic definition is provided therein as the right enforceable solely in equity to the beneficial enjoyment of property to which another person holds the legal title. Here, Weiss references a straightforward definition of a trust, Miss Hamilton explained. A trust is essentially a legal arrangement where one person holds property for the benefit of another. This footnote emphasizes the equity aspect, meaning that it's enforceable by fairness rather than rigid statutory rules. In an express trust, this equity is key to protecting beneficiaries' rights. Alex raised his hand. Is that why express trusts are so focused on fairness? Yes, Miss Hamilton replied. Equity ensures that even if laws change, the trustee must still act in the best interests of the beneficiaries. This principle is central to the trust's protections. Footnote 5. Express versus implied trusts. She continued with footnote 5. See George P. Costigan, Jr., Classification of Trusts, 27 Harvey, L. Reverend 437, 438, 439, 1914. This footnote references the difference between express and implied trusts, Miss Hamilton said. Express trusts are clearly stated and documented, whereas implied trusts are inferred from actions rather than words. By citing Costigan, Weiss underscores the idea that an express trust's purpose and terms should be explicit, leaving no room for outside interpretation. Jamie looked thoughtful. So express trusts are more secure because they're in writing? Precisely, Jamie. Miss Hamilton nodded. A written declaration ensures that everyone involved understands the trust's purpose and terms, which protects it from unintended changes. Footnote 6. Alfred D. Chandler on express trusts. Miss Hamilton read, Express trusts under the common law a superior and distinct mode of administration distinguished from partnerships contrasted with corporations, 1912. This footnote refers to Alfred Chandler's work on express trusts, she explained. Chandler highlighted the unique flexibility of express trusts, which can operate more freely than corporations or partnerships. Chandler saw express trusts as a superior mode of administration because they weren't bound by the same rules and could be tailored to the settler's specific wishes. Tom raised his hand. So express trusts can do things corporations can't? Yes, in many ways, Miss Hamilton said. Express trusts don't have the same registration and reporting requirements as corporations, allowing them to operate with greater privacy and flexibility. Footnote 7. Clarifying the term association. She continued with footnote 7. Mr. Chandler lucidly brought to the attention of the Massachusetts Tax Commission the misapplication of the term voluntary association to the express trust. This note clarifies that express trusts are often mistaken for associations, but they're legally distinct, Miss Hamilton explained. Associations, like corporations, often have regulatory requirements, whereas express trusts are structured privately under contract law. Chandler's work helped distinguish between these, showing that express trusts are closer to private contracts. Footnote 8. Definition of sui juris. Next, Miss Hamilton read, this is defined as of his own right, not under any legal disability or the power of another or guardianship, having capacity to manage one's own affairs, not under legal disability to act for one's self. Black's Law Dictionary, p. 1135, 1st ed. 1891. Sui juris means acting of one's own right, she explained. In an express trust, this concept is critical because it means that the settler, trustee, and beneficiaries are all legally capable of managing their own affairs independently. This is what keeps the trust private and autonomous, without needing outside approval. Alex raised his hand. So everyone involved is supposed to be independent? Exactly, Miss Hamilton nodded. It's all about maintaining autonomy within the trust. Footnote 9. Woodrow Wilson's view on liberty. The next footnote read, See President Woodrow Wilson's address before the American Bar Association at Chattanooga 10, Aug 31, 1910, entitled The Lawyer and the Community. This quote from President Wilson explains the value of individual liberty, which is a key principle of express trusts, Miss Hamilton said. Wilson argued that freedom should be personal, not collective, which aligns with the trust's goal of protecting individual property rights. Express trusts allow trustees to act on behalf of beneficiaries as individuals, not as part of a corporation or group. Footnote 10. The flexibility of trust. Creation. Finally, Miss Hamilton read Harwood v. Tracy, 118 months, 631, 24 SW 214, 216. See also Shaw v. Payne, 12 Mass, 293. These cases affirm that a trust can be created in any form the settlor wishes, as long as it's lawful, Miss Hamilton explained. This is a critical point because it means express trusts can be customized. The settlor has the freedom to set specific terms that fit their unique goals, giving express trusts the flexibility to evolve with their purpose. Chapter 29, Footnote 4, Types of Citizens and Legal Personas. As the students grew more interested in the legal intricacies, Miss Hamilton turned to Footnote 4, which covered a profound topic, types of citizens and legal personas. She knew this would require a slower, detailed approach. What are the different types of citizens? Miss Hamilton read, There are several types of citizens now existing in America. The trustees of an express trust may seek protection under the Constitution as state citizens throughout the Union of States, a jurisdiction outside the scope of the 14th Amendment. To understand this, she began, we need to look at how citizenship is defined. When we think of U.S. citizenship, it's often under the 14th Amendment, which made all persons born or naturalized in the U.S. citizens of both the U.S. and the state they reside in. However, state citizenship existed before the 14th Amendment, relating to each state's laws. Here, trustees of express trusts may identify as state citizens, allowing for certain protections under common law. Rachel raised her hand. Does being a state citizen affect how a trustee is treated legally? Yes, Miss Hamilton replied. A state citizen might claim rights tied to common law, which can sometimes mean fewer federal regulations, especially within the trust's jurisdiction under common law. In rem versus in personam jurisdiction. Miss Hamilton moved on. Jurisdiction over natural and artificial persons is distinguished without a fundamental difference. This stems from the operation of in rem jurisdiction, which underlies all civil law. Jurisdiction can be either in personam, meaning against a person, or in remi, meaning against a thing, she explained. Courts use in rem jurisdiction to decide rights over property. For trusts, this jurisdiction applies primarily to the trust property, with trustees acting on behalf of the trust. Alex raised his hand. Does this mean courts focus more on the property than the person? In a sense, yes, she replied. In civil law, especially trust law, courts may be more focused on the property than the individuals involved. This legal approach is essential for trust protections. The legal persona and artificial persons. Miss Hamilton continued. In rem jurisdiction over a man or woman can only exist if the man or woman is a slave, that is, property or res, an object. This part refers to the historical use of in rem jurisdiction, Miss Hamilton said. Today it's used to categorize legal entities or personas that allow individuals to function in society under a certain legal identity like citizen, taxpayer, or driver. These personas are essentially masks separating the actual person from their legal roles. Jamie looked puzzled. So, a person has different roles based on legal status? Yes, Miss Hamilton nodded. In law, a person can have multiple legal identities, like wearing different masks for different roles. Natural persons versus artificial persons? Miss Hamilton read, "There may be artificial persons but not artificial men, natural persons but not natural men. In the legal system, natural persons are real people, whereas artificial persons are entities like corporations or trusts," she explained. This means that while a trust can function in many ways like a person, it is an artificial entity designed solely for legal functions. Rachel raised her hand. So is an express trust like a person under the law? Yes, Miss Hamilton replied. An express trust is recognized as a person in legal terms, allowing it to hold property and enter contracts. The role of citizenship in trusts. Miss Hamilton read, "Private persons may also pursue constitutional protection as natural persons, citizens within the meaning of Article 4, Section 2 of the Constitution, and may thereby claim entitlement to all the privileges and immunities of same." This is about the Privileges and Immunities Clause in the Constitution, Miss Hamilton explained. State citizens can claim specific protections within common law, which may limit certain federal oversight. Final thoughts on Footnote 4. Miss Hamilton concluded, Footnote 4 brings together principles of citizenship and legal identity, highlighting how express trusts operate as private, protected entities. By using historical principles of citizenship and legal personas, express trusts remain uniquely independent. The students left class with a deeper appreciation for these intricate distinctions, understanding the layers of privacy, independence, and protection that make express trusts a powerful legal tool.
The devil has to play by the rules. You have to make a choice or be used like a tool. The devil has to play by the rules. Your choice in the matter determines wise from fool. The rules of the game are already set forth. And don't you get frustrated and don't you get wroth. And don't let the devil throw you off your course. He's there to be the tempter. Choose Jah at every cost. The Lord is your guide and He is your force. When the devil tries to get you in a doubtful discourse. And don't try to be wiser than the only life source. Jah created all things, so the devil's just a horse. The devil has to play by the rules. You have to make a choice or be used like a tool. The devil has to play by